So Black Belt Barrister's got this video here now, second one down. Now I don't know whether it's pure coincidence and chance that he's pulled out this video 10 hours ago, which talks about the use of harassment within a letter or a claim for a payment. Now the particular example that he uses, the exhibit that he uses, is for licensing fees, right? But it's still meant to be a claim. They're still meant to be making a claim for some money. Now, through the civil procedure rules, the claim, you've got to try and resolve a claim outside of court with the other party. That's actually part of proceedings because you're actually attempting to make a financial settlement with someone, and you're entering a legitimate claim and setting it out, and you're saying that, you're going to use legal action. It's preliminary proceedings. You're actually doing the law yourself because, if there is some law in effect and they owe you money, then, supposedly, they're in debt to you, So you enforce law through the courts. You don't even need the courts to do law because the law's there to apply and obey and follow, right? So, if you walk into a shop and walk out with some pears, then you say, you owe me the money. And he uses law to enforce the payment. If you don't comply with the law, then he takes you to court, right? But it's policing, even civil. You're policing the law, right? Whether it's civil or criminal. Because civil law is, certain laws are to be obeyed, right? Whether it's a criminal or, financial matter, its laws are there to apply and obey. So it's a matter of law, a matter of the law, an upholding of the law. Now, I did a video, or actually put on my page, I mentioned, because when we're looking at process of law, in this 1960 Public Meeting Act, it adds on to the 1908 Public Meeting Act, and it's for mainly council meetings or meetings with public authorities when they can exclude people or the press, but they can't exclude individuals if they have the public in, unless the individuals will be breaking the law, which is set out in the previous act, the 1908 Act, and disrupting a meeting. But that is an offence in itself. Disrupting the meeting is disorderly proceedings or preventing other people from engaging in proceedings, but it's actually an offence under the Act, right? That itself, you might be disrupting the proceedings, but it's not a abuse of the process of the proceedings, right? Because it's the Public Meeting Act. Now, the thing with harassment is usually detrimental effects on persons. It's a little bit like defamation, but defamation is like the publicity and detrimental effects of publicity, people knowing things, and its effects on you. Harassment is the effects directly on you yourself, not necessarily because of it being publicised or known to other persons, right? And it's causing, distress or anxiety. But I don't know if it's nuisance. But anyway, what Black Belt Barrister is trying to make out now, and I'm not saying that this is because I posted anything at all, but it seems it's a miraculous coincidence that I put this act up which says that this 1960 Act for public meetings, it says that because public meetings is a proper process where you're going to be challenging authorities and bringing grievances, likely, you've got a right to bring those grievances. It's going to be otherwise the person answering larger numbers of grievances from multiple persons is going to feel harassed. So that comes with the job. You can't just start throwing harassment into things where someone is likely going to be subject to multiple complaints, right? Because it says that unless it's malice, malice is brought without a cause. So if you've got an actual cause, which is effectively a case, an issue raised, a matter, something that is to complain about, including it could possibly be the behaviour of the individual, because council staff can not comply with the law. So that means you've got a legal right to bring a grievance against them or any of the processes in the council, right? It's saying it can't be harassment because it would have to be malice, which is without cause, because you're always going to have a cause, and a cause, when you're complaining about it, is usually going to be, some kind of stress or anxiety on the staff, basically, or on even the person who might have made a wrong decision and you're bringing the claim. Effectively, the basis for this is basically the legal claim anyway. I mean, this is the thing. If you ended up getting charged by the police and then you defend it and you're found to be not guilty, okay, it gets put in writing that you're not guilty, but you still had a charge against you and your name was still on the listings of the court and you had to answer that, and for a time, it would be official that you were answering a charge or up on charges, even if you later prove yourself innocent, right? And that could be harassing experience to face the charge, but you don't charge the court with harassment. Why? Because they're engaging in process, right? And someone has got a claim, right? Instead, you get what you call is, if you prove yourself innocent, you get, compensated supposedly, or damages to a certain extent, right? But they don't throw in all these extra charges like, you can have vexatious suits. And in fact, that's what the Crown Prosecution Service are doing in a lot of these cases against protesters, bringing vexatious suits, because a lot of these protesters have just cause and they're already engaged in processes to Parliament which aren't getting acknowledged, right? Black Belt Barrister, what he's doing, he's bringing in all these offences and charges and just throwing them all in, piling them up. Well, what can we add in here, right? But it's if you could do that, right, then you could just prosecute the court for harassment every time they charge you with anything, or prosecute the police, regardless of whether you are guilty or innocent, just because the police were harassing you by questioning you all the time or whatever. But it's process of law. You prove yourself innocent and that the police shouldn't have done what they did when you prove that you're not guilty, right? And it's actually the same basis for civil, really, I think. The civil procedure rules are meant to be understood by the average person, right? They're not meant to be complicated. And the civil procedure rules set out all these time limits and so forth for actual legal proceedings and times to lay documents and time slots. It's all in the civil procedure rules, which if you get a letter or a claim from someone, I guess really you should, if that letter has to comply with those rules, the civil procedure rules, and if it doesn't, then they're actually breaking the law. But that's not harassment. What Black Belt Barrister is trying to say with the wording of the actual letter itself, or the claim, he's wanting to bring extra charges into a legal process. The legal process is dealing with the matter without having to go to court or without using court time, if it can be resolved out of court. And if someone's pursuing money, whatever it is for this television licensing charge or whatever. Now, what Black Belt Barrister is trying to do is trying to say that, the particular, basically, your freedom of speech in this letter, it could amount to harassment. But then, it's almost like saying, the letter could be abusive or et cetera, right? Well, I wouldn't, this is the thing, right? You're executing a process of law, right? Just by saying, you owe me some money and if you don't pay it, in the politest terms, you're going to face court. It could be stressful. And trying to get the money out of them, they could say it's harassment, right? I mean, in the 1600s, there was little difference between civil and criminal suits, because you just go to the sheriff. If someone owed you money, get a warrant, then you go arrest them. Now, grabbing hold of someone and arresting them, even if you've got a warrant, or attempting to try and grab someone and take them to the sheriff's office, they might say that you're harassing them or following them around. Well, you've got a warrant. That's the thing. You've got a warrant, and it's been warranted. The sheriff gives a warrant for the arrest, and then, the court gives further warrants for things like search property and things like that. Why don't you prosecute the police when they come and search you, for items? Why don't you do them for harassment? Well, if you actually, when you're proved when you're actually proved to be guilty, apparently they had the right to do everything they did to bring that charge. And if you prove yourself innocent, then they didn't have the right to do anything they shouldn't have done, and that's why you're meant to supposedly get compensation. But this is the thing, there are all these police rules and procedures, right, what supposedly they've got to follow, but the police break those all the time. There's always people complaining about them, and they're doing all these. They used to have the IPPC, but they've changed the name of it now, the Police Complaints Commission, and so forward. What about all these journalists and the police are coming in their houses and chucking their stuff everywhere and throwing things under mattresses or throwing stuff around? Why aren't they prosecuting them for harassment for that? Well, to be honest, it's a criminal process, but you can have a civil process where you go to a court, get a warrant or something because you need evidence, right? You can have a warrant in a civil case or subpoena and compel them to show it, right? Why is this subpoena not harassment? Black belt's going on the wording, but this is the thing. Legal processes, I would say that if someone takes you to court, right, and forces you to do it that you don't want to do, that's harassing. These processes aren't nice, and that's the bottom line. These processes cause anxiety. These processes are a nuisance, and these processes can be even harassment. And this is the thing that Black Belt Barrister, I don't think he's understanding. Because you have claim, right? Because you have cause, you're the one bringing a suit, right? And that suit is not going to be nice effects on the other person. But the fact that you've got a claim. Now, what they're saying is that in these meetings with the council and so forth, it's privileged. So you're going to be given repeated questions, or you might have a number of questions, which, say, like, for example, the Mayor of London might not want to answer. In fact, they've started not answering them. They've started saying, do I have to answer that? Because it makes them look bad. Because if the question is a powerful question or a strong question, and they have to answer it, it can make them look bad to the whole town. And that's what Sadiq Khan, the Mayor's doing now. He's just not answering questions, because it could even be harmful or detrimental to what he wants to do. So he refuses to answer them. This is what Black Belt Barrister is saying about Keir Starmer in government. Keir Starmer isn't answering questions and so forth. Because why? Well, it will be harmful to his manifesto, policy, party, plans. People might suddenly start signing this petition to get them out at any given moment. So what he's doing is refusing to answer direct questions because of the defamatory effects and so forth. But that comes with a job. If you do something wrong, you have to be accountable for your actions. You have to have responsibility. And there's no responsibility if you don't answer a question, because you're not responding to it, and you're not showing ability to respond to it. You're evading the question. This is to do with professionalism and why the government is utterly corrupt. But this is the thing, right? In this Public Meetings Act model, the 1961, it's setting out a model that, because, the nature of the proceedings is not necessarily going to be, nice for everyone involved. It could result, if someone comes with, this is the thing, if you've got a challenging question, you're trying to prove your point. This is the thing. In a courtroom, you're meant to answer questions. If you evade questions, right, and then you don't answer them, because it could, incriminate you because you're going to be guilty, that's the point. Isn't that the point of the barrister, is to answer questions which prove that the person did something wrong? Now, if someone's in the council and the council hasn't done something right, and you ask them a question, if they're evading it, then they don't want you to prove it. And that's the point. It's public accountability, public questions, not only on what they're doing and why they're doing it, but also if they've done something wrong, to raise a grievance or complaint and say, excuse me, why didn't you do this right? And by them actually acknowledging your question and saying that there is something that wasn't done right, and then, well, who didn't do it right, and then, without lying, if they say who did it wrong, then they're liable. But this is the point. Then they're breaching the privileges because they got fraud or forgery. But those are offences for proceedings, not harassment, though, because harassment is something which someone does not like personally, but is repeated, right? Which might cause anxiety. Well, if you work in a council and you've done something wrong, and there's multiple persons asking you questions about it, it's going to cause you anxiety, and maybe you shouldn't be in that job. I don't particularly want to do jobs like that. It takes particular characters who will stand for the position. Now, the thing is, I think, I might be wrong about this, but I don't think I am. Black Belt Barrister is talking about civil proceedings, and he's talking about preliminary proceedings, which in the civil procedure rules is attempting to resolve the matter without going to court, outside of court. And that is actually one of the civil procedure rules, that you attempt to resolve the matter out of court, right? If someone claims that you owe money, right? Now, this is the thing. Black Belt Barrister is posing the question in his video, or essentially, that's one of the things that he's putting forward in the video, that, what do you think about this harassment charge? Well, I say that you can't have a harassment charge, and I don't know why he's attempting to put one into the equation, right? If there is a valid claim, right? If the claimant has a valid claim, they're pursuing that through proceedings. Now, if they're going to take you to court, right, there are set time limits for court, right? Now, if they're trying to scare you and resolve it outside of court by, threatening or whatever, but if they've got a valid claim, right, but they're making out that there are certain timeframes that don't actually exist legislated, I think that's what Black Belt Barrister is getting at, right? Then really I would suggest that was an abusive process, because they're engaging in the process of law, right? They're following the procedure rules and trying to resolve it out of court, but they're claiming there is a time limit that there isn't, or something, right? Which, well, that's firstly, it's a fraud or forgery because of the process, because they're saying something which there isn't, and then secondly, it's an abusive process because they're trying to scare you or frighten you, but it's not harassment, because the thing is, it's going to be causing anxiety for someone to have a claim in the first place, or more than a nuisance, or being an upset, and it can't be malice, because malice is without cause. Now, the thing is, if they don't have a valid claim, and if their claim is wrong, there are another two things which are important. Firstly, if you can prove in court that their claim isn't right, and then it was never right, okay, and you win, and then you get compensation money, right, okay, or they're bringing a false claim, right, on false statements and giving false statements, right, and I would say that if they're making up a time limit, right, which doesn't exist in law, then isn't that fraud or a forgery? If they're saying, if you don't comply with this within so many days, then you're liable to this or that, or I'm going to bring proceedings. But he's got the right to bring proceedings, and he's got the right to say, don't want this dragging on for ages. I've got a claim for some money, right, from a website, and they said 6 weeks, and I waited 6 weeks, and then they hadn't paid me the money, and then they said, 10 days, and then 10 days, and now it's been another 8 months, and it's been dragging on it's getting close probably towards 3 or 4 months now, and I don't know whether they're going to pay it. And every time I ask them, they say, it's a unique special claim, it takes ages to process it or whatever. I've been waiting months and months and months and months. I mean, how long is it going to go on for? You've got to find some resolve. I don't think it's harassment though, because there are other offences and other charges which are meant to be for this, not harassment. Harassment is when you don't have necessarily the right to repeatedly do something which might be causing anxiety. A claim against someone, or the threat of legal process, or the actual legal process, is going to always cause anxiety, because you might as well just say that, because the police are charging you with an offence, then you can charge them with harassment, annoyance, anxiety, all these other things, right? On top of, whether you're guilty or not of the crime, which that's not how it works, right? That's not how it works. It works like they're replacing all the normal. This is why the police have got the right to kick your door down. Is that harassment? If you win the case and prove they didn't, what compensation do you get? Well, you're getting compensation, but it's not under harassment. It's under the fact that you weren't guilty of what they claimed, the cause, and the police were wrong. So you get what you get out of it, but you don't start throwing all these other things in on top of it, because there's a certain. It's almost like, when the police are using these protesters as an example. The police are saying, if you do not yield or comply with me or whatever, I will apply pain to you or hurt you. Well, is that harassment? There's some video clips that I'd like to get of that. For example, the law gives them the right to do certain things because it's a due process of law. When it comes to like language and stuff like that, you can be in contempt of court if you're actually in court, if you're disrupting proceedings or, I think there is an offence for swearing at judges, but also the judge can be guilty of that offence if he swears at you. But it's actually that you can't have harassment in proceedings because otherwise. This is like what Sadiq Khan is doing now. People are heckling him with very tough questions because maybe they actually might have a point or might be right or there might be something done wrong or he might not be giving a true fact or figure or something. This is the thing. If each person in the audience suddenly decides, oh yeah, I'm going to try and answer that question and get him out of him, and then it doesn't answer it for person one, then person two goes, hey, just a minute, that's an interesting question. Yeah, what is the answer to that? And then they ask them it, and then the third person, and the fourth person, and the fifth person, and the sixth person, and the seventh person, the whole audience starts going to the mayor, answer this question, and he could say the whole audience is harassing him, but he's there to answer questions, right? And if someone has got, whenever anyone makes a legal claim against you, it's supposedly meant to be true and honest, because if it isn't, then they're breaking the law, right? They're committing fraud and forgery, right? So every claim has to be on the face of it legitimate, or the claimant's making an offence, right? Or at least this has always been a question in my mind, when any claimant is proved to not be right, and the defendant wins, then was every single defendant's claim false or wrong? If it was proved that they didn't do what they did, then why aren't the CPS lying every time? Because they were right. So why isn't the CPS getting charged every single time for bringing false statements or trying to make a claim, a fraudulent claim? Well, this is the thing. I mean, there can be false statements, but once you take the oath, it's going to be taken as, the truth. You've got if you have reason to believe someone did something, right, then you're never 100% sure. But, is it beyond reasonable doubt? And if they knew for certain, and there is no doubt, this is the thing. When you think someone owes you money, right, I'm guessing that, it's beyond reasonable doubt that they owe you the money. They're not saying that, because if they're saying that, they suspect that you owe them money, right, and they're going to try and prove that. Otherwise, if they don't just bring it on that premise that they suspect that you owe them money, beyond reasonable doubt, then surely they might not owe you money, and you might be making it up. And if you win, then aren't they the ones who committed the crime? And why don't they get charged for a crime and an offence of fraud in the civil court? Now, Black Belt Barrister might say that I'm talking a lot of tosh and write this whole video off. But what I'm saying is, there are proceedings aren't pleasant and aren't nice. And instead of all these other numbers of offences, right, you've got other ones. And when you decide to engage in a process which isn't going to be pretty on the respondent, and not nice to have to, engage with for their time and money, then, it's you don't have things like nuisance. It's not a nuisance or harassment. You've got like a process what you're following, and it's an abusive process. I would suggest that if you're using, abusive language or certain other things, they actually, they deal with, look, right, when you swear at a judge or commit a particular, bad use of language in court, they've got like contempts and things like that. But also the judge can be guilty of it. I got shouted at by a judge, In Parliament, they've got complete and utter freedom of speech. They can say what they want in law, but they still get sent out and punished by their peers because it's judgment of peers, right? And they can be sort of like, but not in these other courts. It's etiquette. If they don't follow the etiquette, they can be sent out. But in theory, they have got complete and total freedom of speech in Parliament. That's parliamentary privilege. I don't think you get complete and total freedom of speech in a court because you can be in contempt. But what I would say is that none of it is nice and all of it isn't a pleasant experience. So why would you use that harassment charge when usually harassment, in the Protection from Harassment Act, it's based around anxiety caused, right? The wording for it is anxiety, not nuisance. Anxiety is more than a nuisance, although you can get things removed from the road if it's a nuisance, but that's not harassment. You can go to a magistrate's court and get something removed from the road just because it's a nuisance, right? For harassment, I think the word they're using is causing anxiety in the Protection from Harassment Act, right? Now, because it's anxiety, it's always, in my mind, it's always going to be anxiety when you receive any legal claim or papers at whatever stage it is anyway, right? So it can't cause anxiety because the process is a process of anxiety, right? So it doesn't matter what wording you use. You're only talking about degrees of anxiety. So it's going to be what they say in this Public Meeting Act for the whole privileges and free speech model is that malice is without cause. But the thing is, if you've got a claim, you've got a cause, or you're claiming you've got a cause. So it's cause. So I've seen them in America and Canada doing these court like public speaking, with the council. That it's a little bit like citizens' question time with the Mayor of London. But in America, they've got various other councils and so forth. And this Canadian girl, she's actually. Or she might be in, it's not Canada, it might be Vancouver or somewhere like that. But she's swearing and effing and blinding, and he tells her to calm her language down, and she basically says, look, you can't censor my speech. So they're actually using it there, which is the same model as what they've got in Parliament, supposedly, depending on, but it's all voluntary etiquette, supposedly. If I try and bring it down more specific, to what Black Belt's talking about, the letter is referring to response time. People can just, drag stuff out for ages, and it can go on. You've got to try and make some kind of resolve. I would say that if they haven't yet actually brought proper proceedings, right? If they haven't brought proper proceedings, then I would say that effectively, it's about the process, legal process. And I would say that, it's an abusive process. If you're trying to claim that there's a time limit that there isn't for a particular part of the process, or pressure someone, is it an abuse of that process because you're trying to make out there's a time limit what there isn't? Or what you're trying to do is you are effectively defrauding them. You're trying to say, oh, there's a time limit when there isn't on this part of the proceedings. I haven't yet actually filed a thing with the court, but I'm going to if you don't do this, right? Well, there isn't a time limit, but you're claiming there is. So that's fraud, right? So you can have fraud in proceedings. The frauds are something you can have in proceedings because you're giving false information or evidence, if you're not sure 100% and you're trying to prove it beyond reasonable doubt, but the evidence suggests it, then it's not fraud because you don't know for sure, but that's what you're trying to establish in the court. You're going to the court because you don't know the truth for certain, and the court's going to decide what the truth is. I think that's what the CPS have got on them. The CPS have got on them that they're not defrauding you because they're just bringing it, he's, going to prove it beyond reasonable doubt or whatever. So that the CPS might know something that could, show that you're innocent. They do get called out on that quite a lot. But I would say that Black Belt's wrong. It's not harassment, and I don't know why he's throwing harassment in there. I would say there's an abusive process or a fraud or forgery, which you can have for legal process, not harassment, because anxiety is always going to result. I would say that a claim of a time limit which doesn't exist for a preliminary proceeding before actual proceedings are engaged in with proper time limits of law given, I'd say that it's a fraudulent or false claim that there is a time limit or you've got to respond in a certain time, which fraud and forgery are offences which can be given in proceedings, or an abusive process, which is that's what the abusive process is for. Perverting course of justice is going to be more serious. I would say that probably would help indicate the difference between abusive process and perverting the course of justice, because an abusive process is that they're trying to use a process unfairly. Time limits that don't exist or aren't correct is a forged time limit or a fraudulent time limit.